But as to that, I mean, your rationale makes it sound almost punitive. Well, I'm sorry, he was just convicted, so he loses the right to do everything that a fellow protester can do. Because I haven't heard any other argument than that for why he loses that right. You know, any of the kind of underlying concerns about Heck don't seem to apply here. So then it just seems to come down to, there's this extra element of punishment, which is you can never challenge this statute again.
Well, to some degree there are consequences to the choice of not invoking your state court remedies. There's certainly that, but the whole rationale of Heck was the indirect method. And a facial declaration of unconstitutionality would be far more impugning than monetary damages ever would. And so if that is the reasoning of Heck, that we won't let monetary damages impugn the prior conviction, then I would suggest a declaration of unconstitutionality, which would mean the law was unconstitutional from its inception. I'm not sure how that would not satisfy the necessarily implies test, and to the government's credit, they admit that it would.
I've seen in other cases, these provisions when you commit a crime, like a particular one, and you're convicted, you undertake not to commit further violations of that provision. Now, if he does, is he subject to reincarceration? Certainly,
that's a big part of the probation in this particular case. So he was under a suspended 10-day sentence at the time that he filed this 1983 suit. And so my friend on the other side would say, well, that's not custody, because that's just saying he can't violate the ordinance, just like any other John Doe on the street couldn't violate the ordinance either. There's a big difference in that. If he violated the ordinance, he would immediately not pass go and go straight to jail for 10 days because he was under the suspended sentence. And that constitutes custody under this court's jurisprudence. And this argument about waiver, from day one, our argument has been that this action is Heck barred. Now, what this action has transformed into over the course of this litigation has changed dramatically. But at every stage, in our cert response, in the question presented, we talked about the suspended sentence. At page 4 of the cert response, we talked about probation. At 31 of the appendix, the district court acknowledged the probation. At page 3 of the appendix, the Fifth Circuit talked about the suspended sentence. Now, there were directly cases on point at the Fifth Circuit that foreclosed the petitioner's argument. So none of these, the probation never was an issue because the cases on point dictated the result in the case. And as
even if the condition requires a complete, the sentence is finished and everything else, but you can't do this thing again, and just, coming back and preaching again. And if you do, we're going to prosecute you, but it's going to be, from soup to nuts. It's not like we just say you did it and you go back. I mean, that's still barred?
No, again, the bar here is the either anything retrospective regarding damages, which was the case that he brought against an individual police officer, or a facial declaration. If he were to make a properly lodged as applied challenge, that would be okay. He certainly doesn't need to go get arrested again. As Justice Sotomayor pointed out, a credible threat is certainly enough to give him standing. The facts of this particular case is that the police chief essentially begged him not to make him arrest him, and he told him, as the district court recognized, I'm aware of your ordinance, I choose not to follow it, and then directed the other people to continue speaking through a bullhorn. So there was all sorts of options absent arrest that he could have followed in this case.
I think the thing that